Excuse me, Mr. Chair, do you mind all turning your mics on? I think they might be off. Yeah, thank you.
Sorry.
No worries.
Roll call has been made, a quorum has been reached. Hopefully everybody had a chance to review the agenda, and it's gotten better. Last month, I got my papers on Saturday. This month, I got my papers on Monday. It's a lot better than getting it Tuesday when you mail it on Thursday. So hopefully everyone has had a chance to look at the agenda. I'll look for a motion to approve the agenda as printed.
Moved.
Second.
Motions are made and seconded to approve the agenda. All those in favor say aye.
Aye.
Opposed? Motion is carried. Now, part of our packet was the minutes from January 28th.
Make motion to approve the minutes from 28th.
Second.
Motions are made and seconded to approve the minutes from January 28th. All those in favor say aye.
Aye.
Opposed? Motion is carried. So do I need to ask if there's anybody in the audience that wishes to speak? Okay, I do not. Okay, so looking for a motion to approve the opening of the public hearing.
So moved.
Second.
Motions are made and seconded to open the public hearing. All those in favor say aye.
Aye.
Opposed? Motion is carried. Take it away, Matt.
Thank you, Mr. Chair. So this is a variance request to the for a structure, or two structures actually, from the ordinary high water level of a public water. So the property and all of the immediately adjacent properties are zoned agricultural, general, and special protection rivers and streams. The use of the property is agricultural. There's a bin site, office shop, storage buildings on site. The applicant is proposing to replace 9 grain bins with a total capacity of 52,000 bushels with 2 grain bins with a capacity of 130,000 bushels. The practical difficulty given was that he would not be able to build on about 90% of his farmyard. If any kind of fire or disaster were to occur, he would not be able to rebuild. So essentially, this unnamed creek here, it's really a ditch. I don't even know if it's a glorified ditch, drainage ditch. It's a ditch. Essentially, these structures are all within that 200-foot setback. A lot of them are quite old. Most of them predating our shoreland rules. And so what the applicant is referring to here is essentially these would be non-conforming structures. If they were damaged to more than 50%, they would have to be moved back on the property behind this 200-foot setback. So, you know, theoretically, this 200-foot setback could be met just by moving these back here. But there are other structures that do exist within the setback. The replacement of all of these grain bins with 2 other grain bins would definitely reduce the footprint and the impervious surface on the site. The proposed bin placement might also be better for farming operations, just considering how this operation is set up right now. I should also note that in 2018, this tributary or this creek was removed from the DNR's buffer map. So that was the buffer law that required that set buffers be put into perennial vegetation on public waterways. This one is no longer, well, it hasn't been on for 7 years now. I know that also the state is looking at updating what's called the public waters inventory. It hasn't been done in a long time, and that process is in the beginning phases right now. It could take a long time for it to happen. This tributary, or this unnamed creek, not being on the buffer map might potentially make it a candidate for removal from the public waters inventory as well in the future. Policy considerations, so from our comprehensive plan, the goals and objectives that relate to this request, we have a goal to protect and enhance the health and vitality of Clay County surface waters, including lakes, rivers, and streams, to maintain and enhance riparian areas of public waters, especially within shore impact zones. This does have a long history of just agricultural activity within that shoreland zoning area and the shore impact zone, which is approximately 100 feet from the ordinary high water level of this public water. As I mentioned, it was removed from the buffer map. The proposed development could also reduce runoff impact as well. And then we have a objective to continue to enforce shoreline regulations on Clay County lakes, rivers, and streams. Granting a variance would make this request, I guess, compatible with the shoreline regulations. Any questions for me at all?
Nope, I don't know, nothing for me.
And on my notes that I had made reviewing things, I was part of the group that worked with Richard in getting this piece removed from the DNR buffer, and I'm just wondering if the tributary, how applicable this setback even is, but that may be something being addressed when, with you saying the DNR is looking at updating the public waters.
Yeah, so, Mr. Chair, even though it was removed from that buffer map, its status as a public water is still in place. And so that's where the setbacks come from. They're not tied to what's on the buffer map, but they are tied to the fact that it is a public water, or listed as a public water.
Okay, well, hopefully that gets, okay.
It's interesting because I don't know if you look at the, let's see if I can pull it up here. Gonna wing it a little bit. So this is our county public waters inventory map. See if it loads. I might have to zoom in. So this is the public water in question here. It really only runs through 3 sections. So some of these were determined though by their drainage area as well. So, and I don't know what the drainage area is on this, but that's how that determination is made in some cases.
I think you needed 2 miles to be considered one, but
Okay. Yeah, so it's definitely one of our shorter public waters in the county.
okay. Thank you. Okay, does anyone else have any questions for Matt? Would the applicant care to come to the podium, state your name?
Brandon Menholt.
Anything you'd care to add or,
Matt did a really good job of kind of saying everything that I would probably say myself. I guess I really don't have nothing more to add.
so a question for you. So according to what we have in front of us here, you're looking at, eliminating a bunch of the old bins and then putting up two single bins with a little bit more capacity to replace the 9.
Yes, sir. Yep.
Okay, makes perfect sense to me. Okay. Anybody else have any questions for Brandon?
No.
Thank you. And as there is nobody in the audience, Matt, do you have anything else to add?
Not at this time, Mr. Chair, just the findings of fact, I guess.
Okay, look for a motion to close the public hearing.
Moved?
Second?
Motions are made and seconded to close the public hearing. All those in favor say aye.
Aye.
Opposed, motion is carried. Now to find the findings of fact. Not as organized as they should be. Very, okay, right here. Does it right there, Menhold Farm. Is granting the variance in harmony with the general purposes and intent of the Clay County Land Development Code? I agree. The purpose and intent of the Clay County Land Development Code applied to this request is to promote and protect agricultural as well as water resources. Placing grain bins within the setback may not appear to be in harmony with the general purpose and intent of the code to protect water resources. However, the placement of these bins and removal of the 9 grain bins would would reduce the footprint of the bin site and consequently the impervious surface. This would reduce the amount of runoff entering public water. Is this variance consistent with the Clay County Comprehensive Land Use?
Yes.
Okay. Does the applicant establish that there are practical difficulties in complying within the strict letter of the Clay County Land Development Code?
Yes.
I agree. Do exceptional or extraordinary circumstances exist that apply to the property in question and that do not generally apply to other properties in the same zone or vicinity, resulting from lot size, shape, topography, or other circumstances over which the owners of the property have no control or influence? Would the literal interpretation of the provisions of the Clay County Land Development Code deprive the applicant of rights commonly enjoyed by other properties in the same district under the terms of this ordinance? Is the variance being granted the minimum variance that would alleviate the practical difficulty? Does the variance request meet all below criteria? No variance shall be granted where any of the following are not met. Adequate sewage treatment systems or water supply capabilities can be provided. The plight of the landowner or hardship is not due to circumstances created by the landowner.
Yes.
The variance would not allow a use that is not already allowed in the planning district. The essential character of the locality would not be altered, or there would not be a significant adverse effect on the surrounding communities. There would not be a significant adverse effect on public health or safety. The variance does not confer the applicant any special privileges that are denied by this ordinance to owners of other land, structures, or buildings within the same district. Conditions may be imposed in the granting of a variance. A condition must be directly related to and must bear rough proportionality to the impact created by the variance.
Oh, Mr.
Don't see
Chair.
any,
Yeah, I don't have any on there, but condition you might consider would be what the setback would be from, what would it be reduced to? So, the proposed, I think, setback that they're looking for would be 130 feet.
are we interested, or looking at putting a number on how many feet they need to be?
You have that on there?
I think it would be good for it to at least not be in the shore impact zone, which is approximately 100 feet. Just because there are existing structures, but,
That are in, but
yep, yep. But I think the proposal is to place them approximately 130 feet from the ditch.
Jim shaking his,
I'm good with
okay. Um, Okay, we would like to put in there that they must be 130 feet from the current ditch. Okay, anybody have anything else to? Okay. Well, I look for a motion to
It'd be Chapter 7, Administration and Procedures. That's the chapter that covers kind of the Board of Adjustments' role, duties, and then also variances as well. And we did have an attorney review that chapter. She provided some great comments on that chapter. And so we're looking at proposing some changes. And the ones that I just want to touch on briefly relate to the review criteria for variances. That's kind of the main one that I want to focus on. So the review criteria for variances, that's essentially the criteria that you use when you're determining whether or not to grant or deny a variance. And for variances and the Board of Adjustments role, it is spelled out pretty specifically in state statute what those criteria should be. Right now, if you look at your findings and the findings, or that's what makes up the findings, what we went through, we have quite a few. Some of them overlap a little bit. Some of them might not really be necessary. And so what I guess I am proposing based off of the feedback that we got from this attorney is just kind of reducing those, excuse me, to 8. And so that would be, some of these are the same. So the first 2 you have to have, they're in statute. The number 3, you also is required, that is in statute too. Really, there isn't a definition for practical difficulty. Just there's three, I guess, components of what a practical difficulty is considered. that the property is going to be used in a reasonable manner. The landowner is not responsible. It's due to circumstances related to the property. And then granting the variance would not alter the essential character of the property's locality. And locality is not defined in statute either. So it could be the neighborhood, it could be the township. It's kind of up to you to decide. Again, looking at 4, the variance would not allow a use that is not allowed in the zoning district in which the subject property is located. That is in statute as well. And then economic considerations alone are not the basis for the variance. You can't just deviate or vary from the code because it's going to be cheaper. That can't be the only reason. It can be a factor, but it can't be the only reason. And then the variance being the minimum variance necessary to alleviate the practical difficulty. So those 6 would kind of be the main review criteria for you as a board to consider, as opposed to we have 8 right now, but then there's one that's got A through, there's a lot. So it's kind of starting to streamline this a little bit. If it's in a flood hazard zone, or if it's in shoreland, you'd have to consider some of these other 2, if there's septic associated with that. But otherwise, it would mainly be those 6. Any thoughts at all? I know that there are some in our current review criteria that might be kind of tricky. The one that I'm thinking of specifically, and I've always thought this, is this item F here, or it's not on there. Here, let me pull it up. The variance not conferring any special privilege that is denied to owners of other lands. The variance is essentially a special privilege. So that's one that's problematic. So we'd be looking at streamlining these a little bit more, and just covering essentially what the statutory requirements are. Does that sound good to?
Yeah, I can see eliminating that question.
Okay. I think theoretically you could deny every variance based off of that. Okay. We haven't not had one of these as part of a hearing since I have been in this position, but also as I've alluded to before, you have another role, and that's to basically, if there is an appeal of an administrative decision, so if I deny a building permit, or if someone commits a violation and they have to remedy it in some way, they can appeal that within, I think, 10 days, and to you as the board. And so that hasn't come up yet. There really isn't going to be many changes to that at all, but maybe it'll come up in the future. And I won't take it personally if you overturn an administrative decision. Not yet. No. No. Cross that bridge when we come to it, right? Yep. Okay. So where we're at, basically, I should also just mention one other thing that's not going to change, because this is also in statute, is that your decisions are final. So if someone wants to appeal in a variance, and any aggrieved party can appeal. So it could be a neighbor, it could be anyone who the court determines as standing. Well, anyone can appeal, essentially. That would go to district court.
Are they subject to the same 10 days that?
I think for district court, it's 30 days. Yeah. And I think Court of Appeals is 60. Okay. Yeah, 60. Yeah. Yeah. So really, I think the goal with just the revisions to the review criteria that are in your findings is just to make it a lot, I think there's a lot of gray area and a lot of room for interpretation, which can be good, but then also sometimes it can be not so good. To just give a little clearer path on what you really need to look at for different variance requests, because a lot of them are pretty open and shut, pretty easy, but there's some that are pretty tricky, can be pretty tricky too. So, so hopefully whittling those down will help with that. Any other questions for me at all? All right. There's also, I will just mention one more thing. In our current code, there's a language that the Board of Adjustment has a responsibility to make decisions on conveyance rights. So if someone wanted to convey development rights from one property to another, that's in our current code. I think we're just gonna get rid of that, because that, I don't think, ever comes up, and I think that's just been carrying over for years and years and years. I don't even know what that hearing would look like. Yeah. Yeah. Yep, so. All righty.
Similar to when you sell a piece of property, your IUP or whatever goes away. So. Okay. Anybody have anything else?
Second?
Motion's been made and seconded to adjourn the meeting. All those in favor say aye. Opposed, motion is carried. Meeting is adjourned. That was